All right, are we ready?
Okay, yes.
Okay, Nora, take it away.
Set. Good.
Yes, thank you.
So good afternoon, everyone. My name is Nora Stinson. I work in the city attorney's office, and I do appreciate your delaying your questions until after.
Oh, I had one for you. I loved it, don't worry.
Okay.
That's why we gave you on
So
roll.
I'm here to talk today about the proposed city council bylaws to replace our current rules. This is a legislative drafting project, and if you're on council very long, you're going to see a lot of legislative drafting projects, and these might include substantive ordinances, resolutions, policies, procedures, rules, bylaws, you name it. And this slide illustrates some of the considerations that we take into account on our legislative drafting projects. People have lots of different viewpoints, and the key with legislative drafting is trying to balance a variety of different viewpoints so that you can essentially compromise on what is best for the organization in the city. There's lots of different ways to organize and draft legislative documents. One thing that you have to keep in mind, English is a great language, but its words do not have mathematical precision. So everybody in our business understands that. One of the primary goals that we have with document revision projects in particular is we're not always seeking, well, it's impossible to create a perfect legislative document. All you can do, especially in a revision project, is you're looking to improve the existing documents. So legislative drafting is an art and a science. Again, keep in mind, there is no such thing as a perfect document. The goal is just to improve what we have on while still achieving our underlying policy goals. So let's turn to the details of this project. So why are we working on this project? We're working on it for two main reasons. The first reason is that it just makes sense from a best practices standpoint to review our documents on a regular basis. So when it comes to our policies, we review those every 5 years. That's just our practice to make sure that we're staying abreast of the law and we are engaging in best practices on the policy side. So when we started to look at our city council, our current city council rules, we realized that while we have amended our city council rules on occasion over the years, we have not done an actual review of the city council rules in more than 30 years, which is way out of compliance.
How many years?
Over
Sorry.
30.
Mr. Pfeiffer.
You were here then, right, Bob?
Yeah, that's I was checking. Sure.
I just didn't hear what you.
So we have not, so we've not reviewed.
I'm sure that was a sarcastic comment.
In more than 30 years. And so we decided, really, it's been a little bit longer than a year, but we decided to take a look at the rules from kind of a comprehensive 30,000 foot view to see what they look like. And of course, we realized right out of the chute that the current rules are disorganized, they're hard to use, they're not very transparent. Another thing that we realized is that we still rely on Robert's Rules of Order, which is a great resource, but it's over 800 pages. So it's just too unwieldy to use on the fly in city council meetings. So we'll talk about another resource that we're recommending that you move to other than Robert's Rules of Order. So that's the first reason, was we just decided the best practice is to review city council rules on a more systematic basis than what we have in the past. And then the second reason is it just so happened that council began to have some conversations earlier this year about whether our current rules were being respectful of everybody who attends all of our council meetings. So that would include the people who want to speak at first public comment period. It would include the people who are here because of a item that's already on the agenda, like a public hearing. It would include the people who want to speak at public comment at the end of the meeting for 5 minutes. And it would even include team members who have to sit through council meetings. And of course, it includes the elected officials, city council that has to be at these meetings as well. And so the discussion over time from city council, and really there's only been 2 brief discussions about this, it became focused on the first public comment period. And the last thing I'll mention from this slide is if you want to know who's working on this project, obviously legal's working on it. So I work closely with Rachel on this. The manager's office, Dawn, Linda, Allie have commented on this, as well as the clerk's office. So that's Kristen Rush. And then our former city clerk, Chris Koch, has also played a role in this. So our institutional knowledge at the clerk's office actually goes back more than 30 years. So they have been super helpful. So thanks to all of those employees. In terms of the background and the context for this, as I mentioned, we had started looking at this project probably over a year ago. Our first discussion with council that I was a part of happened in July of this year. The comments at that meeting they really focused on that first public comment period. And of course, you all know that the comments at the first public comment period are not limited in terms of time. So public comment could last a half hour, it could last an hour and a half. We don't have any control over that because it's controlled by the number of people who sign up and the length of time that they speak. So the takeaways from that first brief discussion in July of 2025 this year was whether allowing the first public comment period to continue without limits was respectful to those who attended meetings for a reason relating to an item already on the agenda, like a public hearing, where I'm guessing probably over time, the majority of our citizens probably come to a meeting to speak on a public hearing matter. And then the other takeaway from the discussion in July was whether the uncertainties around the length of the first public comment period actually work to discourage other forms of public engagement. In other words, were we making people sit through an unpredictable first public comment period, and then did that actually discourage some people from staying to comment at a public hearing or at the second public comment period? So those were my takeaways from that July discussion. And then I incorporated all those comments into the first draft, which I presented to council back in September. So some of you will remember that. So we had a rough draft, and the suggestions from that September meeting, again, a pretty brief discussion, but the suggestions were to be specific in allowing for flexibility around topics that could be addressed in the first public comment period. The next suggestion was to look for ways to create reasonable time limits around that first public comment period. And then the third thing was a suggestion that we collect data from other cities about how they handle their public comment periods. So those were my takeaways from that second brief discussion. So again, the comments at both of those discussions really focused on the public comment piece of public engagement. So those two discussions resulted in the goals and objectives for this project. One was to balance out or at least factor in efficiency to how we do our business at city meetings, and to make the rules easier to understand. So make them more user-friendly, have more streamlined rules of parliamentary procedure, reduce friction points or possible friction points over procedural points. And those are usually caused by a lack of clarity in the existing rules. Another takeaway that I got from those conversations was to provide flexibility within a relatively structured format. I think that was a suggestion from the mayor. The other thing that we look for was to try and conform and modernize language in the existing current rules and to reduce repetitive language, because there's a ton of repetitive language in the current rules, which make them difficult to use. So with this in mind, let's take a look at some of the big picture changes to the rules. So the first thing you'll notice is that we renamed the rules to be the bylaws. And this was really for a matter of convenience more than anything else. First of all, it conforms your bylaws with what I think are the bylaws of most of our other boards and commissions, because they typically have bylaws. So all of our boards, councils, and commissions will have bylaws. So that's the main reason for that. The other thing that we did was we tried to put information in tiers, like TIER tiers. And so we created in our bylaws document, we created bylaws, and then they're followed by 9 appendices on more specific matters, so that you don't have to just look at a 30-page document, which is what we have now in our rules. Instead, you can look at the bylaws for some real general high-level information. And then if you want more specific information, like how we run an executive session, or what public comment at public hearings look like, or the roles of all of the team members who have to attend our meetings, like the city manager or the city attorney or the city clerk. You can just quickly pop back to one of the appendices and that'll give you the information you need. So it should be a little easier to use. So what we did after that, after we created this tiered level of information, I literally just loaded information from the current rules and I just pushed them over to an appropriate place in the new bylaws. So about 95% of all the work I did was just literally cutting and pasting from one document into the other. And I'll give you an example of how this worked and how reorganizing the information leads to more streamlining. So if you want to look at the different types and purposes of city council meetings, we have 5 different types of city council meetings. And if you want to figure out the basics about those meetings, like if you want to know the types and purposes of the meetings, or if you want to know what time and day they occur, or other background information about those meetings, if you try and look that information up in our rules, you have to look at pages 5, 6, 7, and 8 of our rules and sort through all that text to just figure out the basics about what kind of meetings we have and what their purposes are. That doesn't seem very efficient to me. And that's not even covering like what the public comment rules are attached to each of those meetings. So our current rules make it really difficult to find even the most basic information. And so I took all that information about the types and purposes of all these different types of meetings. And what I did was I consolidated it into one page. So if you look at the bylaws appendix 1, I've taken all that information that you would otherwise have to glean by reviewing 4 pages of text and then some, and I simply dropped it into a chart or a table so that it's easily accessible at a glance. So you know what types of meetings we have, what their purpose is, what day and time they're held, along with some additional information, even including some basic information about the public comment rules for each type of meeting. So that's what 99% of this work consisted of, was simply moving and consolidating information. Okay, and then the last thing I'll mention is the proposed bylaws adopt streamlined rules of parliamentary procedure. So Robert's Rules of Order, as I may have mentioned earlier, is like 800 pages long, and it is ridiculous to try and use it at a city council meeting. So it's a great resource, but it's just not the appropriate resource for a city council meeting. And attorneys around Colorado, around the country, I think have realized this. And it just so happens that there's an attorney by the name of Robert Widener, who used to work here many, many years ago. And he went to the private sector and he is now a municipal attorney, very well regarded. And so he's represented municipal corporations around the state for many, many years. And it just so happened that his area of specialty is parliamentary procedure. So over time, he of course realized, like most of the rest of us, that Robert's Rules of Order is really difficult to use on the fly during meetings. And so over the years, he's been in the business longer than I have. Over the years, he ended up writing his own book called Bob's Rules of Order, which I think most of you are familiar with. We have not technically adopted that, but one of the changes that we're trying to make with the adoption of the new bylaws is to also adopt Bob's Rules of Order instead of Robert's Rules of Order. These are endorsed by the Colorado Municipal League. In the surveys that I've done, some other cities are already starting to adopt them because they are concise and they're written specifically for Colorado city councils. So it's a great resource to have in Colorado. Okay, so what does all this mean? It means if you look at the bylaws, you're going to see that the bylaws, which are about the first 10 pages of the draft doc, are arranged in 4 sections, very general information that ranges from, just very background information about, where do we get the authority to create bylaws? How are they different from other documents in the city? A lot of information about meetings generally, about open meetings and how the public participates in our meetings, and about meeting logistics, like how the clerk's office prepares the agenda. So real basic information about city council meetings. And then, as I mentioned, the bylaws sections are followed by the bylaws appendix section. So easy peasy. Okay. So let's take a look at this idea of public engagement in Arvada because most of council's comments about the proposed bylaws have been about public comment and the idea of public engagement generally. So let's take a look at public engagement in Arvada. Arvada offers more opportunities for public engagement with our elected officials, you, now than at any time in our history. These icons represent some of the ways that our community can get in touch with you, and I actually think I missed a couple. Rachel Kay's our expert on this, but I actually think I missed a couple of ways that people can engage with members of council. So one aspect of public engagement is public comment, and when I think of public comment, I think of it being a situation where elected officials can listen to what members of our community are talking about. So public comment under our system and under our tradition is really a listening session. It's not a back and forth. That's really not traditionally how we've handled it. It really is just time for elected officials to listen to whatever concerns members of the public might have. When we talk about public comment, we're really talking about two types of public comment. One is what I would call regular public comment. This usually unfolds at our business meeting. And as you know, we have two periods for public comment, the first public comment period and the second one. And so that's the first type of public comment. And I'm just going to call it regular public comment or PC. And then the second type of public comment that we offer at our business meetings would be usually attached to a public hearing. And you see it most often in like a quasi judicial hearing about a development matter or something like that. It's also attached to other types of public hearings, but usually most of the concerns are around our quasi judicial hearings. So let's move to how the current city council rules treat public comment at our meetings. And then we'll talk about rules for public comment at public hearings a little bit later. So this slide just describes how we currently handle public comment at under our current rules. One of the things that you'll notice here is, as I mentioned, council holds 5 types of meetings. The only 2 types of meetings where our current rules are relatively clear about public comment are our business meetings, where it makes clear that there's 2 public comment periods, and then workshops where public comment is currently allowed in the sole discretion of the presiding officer. Study sessions aren't even mentioned in our current rules. I mean, they're just not mentioned, period. Public comment around special meetings, that's unclear. And public comment in our emergency meetings, current rules are unclear about whether public comment is allowed in our emergency meetings. So what we have done is we've just developed practices over the years to fill in some of these gaps. Can we get by with the current rules? Yeah, sure. We've been doing that for decades. The question is, should we look at moving into the 21st century and filling some of these gaps and ensuring more transparency for staff, for elected officials, and for the public. So I mentioned that City Council had asked us to survey other cities about their public comment practices. So I wanted to take a minute to discuss that. And I provided a chart in the information that I sent you that will illustrate some of this information. So when you look at the peer cities, and we looked at surveying 10 other home rule cities, and those showed up on the chart that I sent you. So the 10 other home rule cities that we surveyed were Aurora, Boulder, Colorado Springs, Denver, Fort Collins, Golden, Lakewood, Pueblo, Thornton, and Westminster. And these were just chosen because they're the usual cities that are generally considered to be somewhat similar for us up and down the Front Range in Colorado. So when we looked at these peer cities' public comment processes, a couple of things stood out. Obviously, all of the cities allow for public comment. All of them have some form of sign-up procedure, which I assume is done to protect the record and ensure fairness in their public comment process. So there were a lot of similarities between the cities. But the other thing that I noticed from looking at the survey information is that Arvada is actually kind of an outlier in a few areas, and I've highlighted these here. We are the only city of all the cities surveyed that offer 2 public comment periods. There is one city that has an option to do a second public comment period if certain conditions are met and at the discretion of the presiding officer. But otherwise, all the cities only offer one public comment period.
Nora, with respect, I know for a fact Lakewood does too.
That's Lakewood.
Yeah.
That's the city I'm referring to.
Oh, okay, thank you.
Okay, so, so we're, in my view, we're kind of an outlier there. And I'm not making a judgment call on that. I'm just saying that's the factual information. Another place where Arvada is an outlier is that we do not limit either the number of speakers or the total time allotted for public comment. And all of these cities regulate one or the other. So we're a bit of an outlier there. And then the third area where I thought we were a bit of an outlier is the total amount of time that a person can engage in public comment at one of our council meetings. If someone were to speak at the first public comment period and the second public comment period, that's 3 minutes plus 5 minutes. So we have to give people a total of 8 minutes. Some cities these are the cities, of course, that have one public comment period, but they limit their public comment period to 2 minutes per speaker. And the average is 3 minutes of these other peer-reviewed or peer survey cities. So we offer quite a bit more time than other comparable cities in terms of overall public comment time. Okay, so those were kind of the takeaways from the peer city survey when it comes to regular public comment period. So let's move on to public comment about the first public comment period. And these are some of the concerns. And so we talked about this a little bit earlier, but the concerns are understanding the big picture here, how our rules are set up, and now looking at the peer city survey information is whether allowing that first public comment period to continue without limits is respectful to everybody else who attends these meetings, either because they want to speak at a public hearing or because they have to do a presentation or have to be present to answer a question posed at a public hearing or what have you. And then the second question was whether the uncertainties or the unpredictability of that first public comment period was working in some ways to discourage other forms of public comment at meetings. In other words, was it discouraging people who might have childcare obligations or other caregiving obligations, or maybe just, people who have to work at night or people who have to work early the next morning, where by having an unpredictable first comment period, were we somehow working to lessen their ability to engage in public comment? Rachel actually ran some numbers, was kind enough to run some numbers around how long our first public comment period runs. And this goes to the unpredictability piece of it. So in 2025, she found that our first public comment period runs anywhere from the shortest amount of time was 2 minutes and the longest amount of time was 72 minutes. So it could be, X amount of time or X times 35 amount of time. And that's the unpredictability piece that I think council had expressed some concern about. So as I mentioned, council seemed to be seeking a little bit more certainty and consistency around that first public comment period in order to be respectful to all of our attendees. So the differences between the rules and the bylaws when it comes to that first public comment period, this slide shows you several things where we have tried to clarify the difference between the rules and the bylaws. And most of these are just clarifications. We did provide more certainty about the length of the first public comment period so that we limit it either by the number of speakers, either 10 speakers or after a half hour has elapsed. And the only consequence of that is that somebody who has signed up to be number 11 or number 12 would simply be moved to that second public comment period where we would allow them 5 minutes to speak. Some other things that didn't make the slide that are differences between the current rules and the proposed bylaws are that we ensure in the new bylaws that people can provide public comment at both public comment periods. That's unclear in our current rules. And we also ensure that public comment is allowed on presentations. That's unclear in our current rules. So the benefits to the changes as it relates to public comment is, in my view anyway, it provides additional clarity and ease of use for people who have to look at the rules. It provides some benefit to people who want to speak at public hearings or to those who have to stay to answer questions or make presentations that are already scheduled on the agenda. And it probably even benefits people who want to speak at the second public comment period. Again, it just gives certainty to everybody throughout the meeting. If there are some disadvantages to adopting the proposed bylaws, it might be to those people who, and there aren't many of these, but people who are number 11, 12 or later, they would be moved to that second public comment period where they'd be allowed 5 minutes to speak. And then the other big disadvantage of adopting the bylaws is it's change. And change is really difficult for people to accept, even positive change. So, to kind of round third base here and finish up this presentation, I wanted to also just check in with you about the second type of public comment. So this is public comment at our public hearings. So this slide illustrates the differences between public comment at public hearings between our current rules and our bylaws. So you can see what our current rule 2F allows on this slide. And then in our proposed bylaws, under Bylaws Appendix 7, the rules are the same, except that we've clarified a couple of things. We provide that written comments about the public hearing are provided to City Council, which is our practice now, but we've codified it into the bylaws so that everybody can be assured that if they prefer to do written comments instead of come to a City Council meeting, they can do that and their comments will go to Council. We've also clarified that individual speakers at public hearings get 3 minutes to express their views, which again, I think is our current practice, but it's not codified in our rules. And so this gives everybody clarity around how much time they'll get. One thing we did note is it goes to that provide flexibility within a structured document. And so the other thing that we did with regard to the proposed bylaws is if we have, for example, if we have a really important public hearing where we feel like there's more time needed, Council can change the total amount of time given to each side with the consensus of Council. Again, to give you guys a little bit more flexibility on how we handle public comment on important public hearings. So that's what I have for you today. One of the questions that I wanted to leave you with was one that we talked about in the information that I sent you last week. And that has to do with, and I cannot remember which member of Council brought this up, but the idea of possibly pooling public comments at public hearings only. And you'll notice on the survey materials that there are, I think, a total of 3 other cities that allow this practice of pooling. And what that means is when you have a bunch of people signed up for a public hearing, that if some of those people want to yield their time to a spokesperson, they can do that. And so there are at least 3 other cities of the surveyed cities who do that. They all have a lot of rules and kind of guardrails around that practice. This is running from either a little bit or a lot more work for the clerk. And it usually would occur prior to a meeting when they're kind of busy anyway. So, but you can create some rules around this, like it has to be done only with pre-arrangement with the clerk's office so that this doesn't get sprung on the clerk at the last minute. This is usually not a minute by minute transfer. So for example, 10 people from a particular neighborhood organization or HOA might want to pool their time and give it to a spokesperson, but that spokesperson might be limited in time to, 10 minutes or what have you, so that you can allow several HOAs to talk about a particular matter or several groups and still allow for individual public comment. So we can create lots of rules around pooling if you decide to go in that direction. You don't have to adopt pooling. Most cities don't fight for it, but if you decide that's something you want to try, we can certainly write that into the next draft of these rules. So that's what I have for you this afternoon. I know some of you had some questions, so we'll take a look at questions and comments. And then really the last thing I have other than your questions and comments is just to let you know what comes up next. If you decide to move forward with this, all we'll do is put whatever the final draft of the bylaws are on the agenda so that you'll vote on them via resolution. So that's what I have. Questions? Shauna?
Yeah, so I would say from the beginning with the goals that the goal wasn't about respect, but infringement of rights. So that if we are allowing like people who don't live in Arvada, for example, to come and do long public comments, and we have Arvadans who are here, or like the other things you're talking about, like people have childcare, people who are working late, it's an infringement of their rights that they do not have equal access to speak as people who just first came and signed up for public comment. And I want us to keep that framing because I think it's very important that we are centered in that we are balancing the rights and access to express First Amendment. And we're not talking about, oh, is it respectful? Is it nice? That's not, for me, that's not
Yeah,
the issue.
I understand.
The issue is about access and infringement of rights. So I would like for us to reframe it from respect to the freedom and encouragement of free speech. And then at one point during the presentation, you showed us a guide that had blue titles at the top that had the types of meetings and the comments available to the public. And it seems like that's just an internal document. It doesn't seem like that's a document that is available to the public. And is that going to be like eventually publicized so the public knows, okay, so I want to make my comment at a public hearing. Here's what I should prepare for. Here's how I can pool or whatever it is.
So a couple of things about that. All of the charts went out attorney-client privilege, so they're not made available to the public at this point. A couple of things. So some of this is a little bit off in the future, assuming council adopts the proposed bylaws, but there are some ideas that we could use to make all this information available very quickly to the public. Some cities have a little, box of information literally on their agendas that say, this is how you can participate in this meeting. We also have that FAQ document, which again, assuming you move forward with the proposed bylaws, we'll make all the FAQs available. And also we've got the bylaws themselves. So all of this should be, when you package it all up, we should have a variety of different resources to provide for people. But I agree with you, we should probably this is a great opportunity to be more transparent with the public about how are these ways, what ways can you engage with council at our actual meetings, whether it's through regular public comment or public comment at our public hearings.
Great. My next question is, you showed a slide of all the different ways that people have access to electeds, but I'm pretty sure that if somebody comments on the City of Arvada Instagram page about me, I do not see those comments. So I'd like to know, like, of all the different ways, can we sort out, this is like official of the record? Like when we do public engagement, like I feel like Instagram comments and even Ask Arvada don't Arvada Ask, the community survey thing we use, that doesn't enter the public record unless it comes up in as evidence from a survey for something that we see, but that engagement tool gets used for operational items that never come up to council. So of all the ways that the public can engage with council, I'd like to know, like, which ones are of the record, which ones get forwarded to council members personally for a response, and which ones do the city handle, like, so that make that clear for us and for our constituents who think that, well, I told Arvada on Facebook about my water issue, so why hasn't Councilmember Ambrose fixed this for me yet? Like, it's confusing. Because for me, the only record I know is like if they call me and I forward that phone call or record of that phone call onto the city. If they email me, that is written. If they mail me, that comes in. Or if they contact the city through any of those mentioned, then that gets into record. But all the social media stuff and the survey gathering stuff, I have no idea when that gets into record or when I hear about anything that gets collected that way. So that's my question, is like, how many of those are on the record and how many do like we as council members actually ever see or know about? And I don't expect you to know that right now, but I would like to know and make that clear to the public so that they're like, yeah, talking about it on Nextdoor is not the way to lower your water rates. I also would like to know, or if we've done a survey of how many cities, both locally and nationally, have been sued on freedom of speech limitations in time or number of speakers. If that has been fine, or if like I imagine that it's like we accept written comments after that point. So technically, First Amendment rights are still, not limited because we will take all of your written statements, as much paper you want to print and bring to us or email us. Yeah.
Well, we have the ability to impose reasonable time, space, manner limitations on these meetings.
Yeah.
Otherwise, I mean, if you can't impose reasonable time, space, manner limitations, we would be in trouble. But imposing reasonable time limits, as long as they're reasonable and certainly based on the Pierce City information, that would suggest that
Right.
having some reasonable limitations around our first public comment period would be reasonable.
Yep.
So I'm not the expert on this, but I would not anticipate a lot of legal risk simply by limiting that first public comment period to 10 speakers or a half hour, particularly in light of the fact that we have a second public comment period where people can engage in the exact same type of behavior and can talk about pretty much any topic they choose.
Nora is absolutely correct on this. There's a lot of case law out there that talks about reasonable time, place, and manner restrictions in the context of a council meeting, including limitations on the amount of time that people can speak. So as long as we're not trying to impose restrictions based on the subject matter or based on the, and there are times we can restrict the subject matter, but that's how we have to set up the forum. But also, we're not restricting speech based on viewpoint. So we can say, everyone, no matter what your viewpoint, no matter what your subject matter, you have 2 minutes or 3 minutes to speak. That's okay. That's been blessed many, many times. So I'm comfortable with that. And also, one of the other things that courts look at are whether there's reasonable alternatives for speech that was not permitted. So here, if you don't get the 3-minute public comment, you'll get the 5-minute. You can also send an email, you can mail, you can call. There's a lot of other opportunities to engage with council members. So.
Okay.
Here, nope.
I got 2 more.
Okay.
Sorry. And then towards the end of your presentation, to me, it wasn't clear about what, when you brought up the bylaw from Article 6 about whether that clarification are limitations that we already have on the books, or if that was what you were suggesting for us to change to. So, so is Article 6 of the bylaw, or Appendix 6, sorry, of the bylaws, something that's already on the books that clarifies these restrictions that we could just go ahead and start doing without?
These would be part of the bylaws appendix that you would, if you decide to adopt the proposed
Okay,
bylaws.
so this is not,
Correct.
okay, this is a proposal.
Right.
Okay. If we structure that public comment is allowed on all resolutions, not at the discretion of the presiding officer, how would that change the flow of the meeting?
Well, it would all be within that first 30-minute public comment period. So my assumption here would be that the presiding officer would ask for people to, they're free to comment on a topic of their choice, including a resolution on the consent agenda, or in those cases where we have a presentation, they could comment on a presentation as well.
Okay.
So I don't know that it would do, I mean, if anything, it would probably, streamline things because you wouldn't
So
necessarily.
you're putting all the comment in one place. Okay, all right. And then can you go to the next slide about suggestions? Okay, so this is just for public hearings, which is different than the pooling suggestion.
So the pooling suggestion would apply to public hearings and not regular public comments. So it would just be in the context of public hearings only.
Right.
And this would be, you have an HOA that has a particular pro or con view, and you have 20 members of the HOA or neighborhood association or whatever it is, or maybe they're affiliated with a nonprofit of some sort, and they all have views that generally align with each other. They may be familiar with each other, and so they could come in and 20 members could, rather than each, this is their choice, but rather than each go up there and make individual comments, they could say that, oh, the president of our HOA is here and we want to yield time to that person as a spokesperson. And so they would just yield or cede their time over to that spokesperson. And again, the key is, most of these cities put some guardrails around it. So you arrange it beforehand. It's not a minute by minute transfer. Most of the cities, because otherwise that would sort of defeat the point. And then most of the cities have a rule where the person who yields the time has to be present when the spokesperson speaks. And I assume that's to Wade where.
Yeah,
when
that's the way
people say-
Denver Public Schools in Denver is. Yeah, okay.
So
that-
just common sense.
Yeah, that really helps because I was like, how is 1 hour proponents different than pooling, or is it pooling, or is pooling a part of the 1 hour for proponents,
Yeah,
1 hour
pooling
for
would be
opponents,
part of
right?
that.
Okay. Yeah, and then your question at the end, I'm in favor of looking at pooling within reasonable limits for public hearings and for regular public comment, and as long as like it doesn't drive Kristen insane. That's all I've got.
Sharon.
Yes, thank you. So there is an answer to your question about people from Arvada being able to be heard first in BA 6.3.2 order of speakers. The presiding officer, presiding office, I think it should be officer, may give priority to a speaker who is a resident of Arvada during public comment period. So that's really cool.
And
My,
that- oh,
I'm sorry.
Existing or bylaws? 'Cause
This is
BA
in
doesn't-
BA 6.3.2.
Is that
Is that existing or is that something that's being
Yes.
proposed?
existing? It's existing.
So I just
Actually, I
wanted
think it
to,
may be in the existing, but it got pulled over, so it is in
Yeah.
6.3.2 of the bylaws
Yeah.
appendix.
I just was,
So we already
I
have the
just saw
ability to
that,
do
yeah.
that.
uh-huh.
I don't think
So
we do it though.
We just
Yeah.
don't do it, but
No,
I think
historically-
sometimes Lauren has done it.
I'm not sure I actually have done it. I don't think I have.
Mark Williams said-
Well, and
People
I
like at the
have a
end.
question on that, on legal
I think
risks,
so.
like, is that one of the things where we're discriminating people's public?
It's right here in the.
I mean, I know it's in our bylaws, but that doesn't mean people won't sue us over that, being like, even though I'm from Missouri, you're infringing on my right to speak by favoring Arvadans. Yeah.
But.
You
so
can
then-
speak without an address.
Yeah, I
You
would
would say I don't
How do you
wanna,
enforce it then?
right,
Well,
Yeah.
presiding officer will ask the speaker to state their name, their address, neighborhood, subdivision, or council district. And I think that when things are a little dicey, we should really emphasize that if you're not comfortable with your address, giving your address, at least your council district or your
They don't
subdivision.
know.
Well, but they know that they live
say
in
like cross
Maple.
streets.
for zip code.
Yeah,
Yeah,
or zip code, yeah, they know there's.
Just so you know, that has not been an issue in 14 years. But I,
Well, I don't know, I'm just saying that.
but I do
Well,
want,
it's during trash,
but I do, well, I mean, we had Walmart and.
I have
that
a
went on
question
for
about the legal risk of this, so yeah.
And I was gonna respond to that. Long story short, I'm not concerned about the legal risk of allowing Arvada residents to go first. I can follow up with a memo that gives you a much more detailed description of why, but that's the
Great.
short answer to your
Okay.
question.
Great.
And the other thing I should mention is that the current rules say that the presiding officer has the discretion to determine whether the order of speakers shall be, it says any Arvada citizen first, and then any other speaker in the order determined by the presiding officer. So that's been our rule. for
I saw that. We have not done that historically. I don't recall Mark Williams doing that. I know I've never done that. But that said, if we do see a large wave, like that one time we had all those Denver residents come,
Right.
then I think in that case, just this gives us clarity and go ahead to perhaps, okay, we see a bunch of Denver people have signed up. We're gonna allow them to go, but they have to go to the end. So.
and if we have that, if we have a time limit, they may not be heard at all. Or they'll be at the
We'll
end
have
of
to
the
go to the
meeting.
end.
Yeah, so that's just something that I wanted to make sure, because sometimes people just aren't comfortable giving their.
And we don't
So-
force them to. We've had numerous folks give their council district or their cross streets or their neighborhood before, and I've
neighborhood,
always
yeah.
allowed that. So,
Mhm.
who is next?
Are you done?
I'm done.
Randy.
Okay, I have a long list.
Okay. Okay.
I appreciate, thank you, Nora, for all the work you put into this and the team on this. So going back to the comment about different ways the public has to engage with council. I think, you know, there are multiple ways, but I think we also need to understand that public comment is valued differently than those other ways. And it is, so it's not, I don't see it as equal. It's very public, in that, in the very nature of it. And so I think it's not justified to treat it equally as the other ways that people can engage with us. And so I just want to start with that comment, but so I'm just gonna kind of go in order of the red line version and the pages that I found stuff on. So there's two references to informal council session. I caught one on page 17 and one on page 34. And both of them which say they're not to be live streamed or recorded. And I think, you know, that the informal council session, I'm assuming the 5 o'clock counts as an informal council session. That we need to have more clarity and transparency around that. And I would like to see that added to your chart that you're creating of different types of council meetings. And have it very clearly defined what the purpose is, you know, you've got a place for public engagements not allowed, you know, so forth. So that's all clearly defined in what that, what an informal council meeting is as another way of council convening. And then I take heart to the, I beg to differ on not recording and live streaming those. So I think that they should be treated similarly to our study sessions and be live streamed and recorded like our study sessions are.
Can I just interrupt you? Can you
Yes.
tell me what section you were in?
I had page 17 and page 34 are both places that I saw informal council session was referenced
In the red line.
in the red line document.
Oh, in the red line.
Oh,
Okay.
I was confused too.
Okay, sure.
So what you may be looking at is in page 13 of the clean draft. And it does mention on page 13 of the clean draft that each regular business and workshop meeting will be preceded by an informal meeting session that will be noticed and open to the public as set forth in these bylaws. So that's I think the initial reference is probably
Okay.
page 13 of the clean version. And then give me a minute and I'll keep looking for that.
I think
second.
that right there solves a little bit, because I don't think we did that at least consistently.
Sure.
I'm not sure.
No, I think that's
I
important.
think as long as they know there's a preceding meeting.
And then we're
And everyone's
noticing it.
welcome.
Yeah.
When I first ran, I sat in here, watched them all eat.
Right.
Weird, but
It's Aki, you gotta bring your own lunch.
But I would like to see us look at why can't we live stream and record those for access purposes. So, yeah.
Oh, Randy, hold on.
yeah,
Rachel?
one quick
Yes.
thing that I wanted to point out, the way it's worded right now, it seems like we have the ability, it doesn't limit how we provide public participation or public attendance. And so I think even with the way it's written, as long as it doesn't say we can't record or live stream, I think we'll be okay.
Well, that's how I read it, that it says now, will not be live streamed or recorded.
the old document though, right?
Yeah.
The new proposed, she's not saying that.
Okay, well, we need to check, because I thought it was in the red line version, that it was included now. And then, so this kind of sidetracks from what has been presented thus far, but this came up in the Ralston Valley Coalition candidate forum. They say that the Jefferson County Commissioners allow the removal from a consent agenda by a request from the public. And so that was a request being made that we consider that. So I would like to explore that and just put that out there as something for us to look at.
Can we validate that?
Yeah, right.
I don't want to take somebody's word. I'd rather.
No, sure,
Yeah.
for sure. That's what I meant by explore.
Okay.
Do research on it,
Just
I'll
ask.
Google it.
Give us
Ask
back,
Rachel.
yes. And, okay, and then, so the limiting of public comment to, I'm having a lot of consternation over this, and it kind of dovetails, I think, some of the comments that Councilmember Ambrose made about, you know, are we infringing on rights and how is that perceived? I feel like limiting to 10 or limiting to 30 minutes is too few. And so then it becomes a question of, you know, what's the upper limit? And I'm kind of wondering if a possible proposal would be to allow for an hour and then at the discretion of the presiding officer, depending on how many people actually have signed up. So you get to an hour and you have two more left. Do you just cut it off there or do you allow those two?
Mhm.
But if you have 30 left, then you can say we are going to stop here and bump it to the
Meeting,
5.
yeah.
So that's kind of where I would like to see us go and consider as an option.
Well, just for clarification, CML and Dr. Cog have 45-minute public comment periods. So we might want to use 45 since it's being done.
I feel like 30 is really short.
Yeah, 45
And I feel
might
like
be a
10
good
is too
compromise.
few,
Yeah,
but
right.
so that's just kind of that's my response to that. And let's see. So I'm in favor of the pooling and really I think we need to clarify that in writing what that entails because something we have practiced, but it's not
Mhm.
in writing. So I think that needs to be very transparent about that process. So I would like to see that. I'm a little unclear on when we say testimony for the proponents is an hour and an hour for opponents, when the opposition is many times many individuals that aren't together in a group or any sort of type of organization. So and then we were talking about this pooling option. So how does that translate? I guess is my question. When we're saying we're limiting the opposition to an hour and then we allow individuals to have 3 minutes and we would allow pooling. I just think there's gonna be more clarity about what the pooling means, I guess is where my question on that.
And the information about the, hour each comes from the current rules. So
Correct.
That's just what we're playing with now.
Correct.
But we can certainly create transparency around the pooling piece.
Okay,
Yeah, and just to build on that, if I may, that was one of my exact questions, was the opposition specifically a reference to when we have an appellant, like with Grandview Station and Lori Dryenka? When there's a formal appellant with a case also and they get the hour? Or is it actually the public comment piece where you have a unified neighborhood group or something like that, but they don't have any kind of current legal standing in the matter? That was my question for clarity as well.
So I basically just pulled it over from the current rules,
Yeah.
which gives the opponent or the applicant 60 minutes and the same amount of time on the other side. That's just the current rules. I didn't change it, but we can.
Well, that's what I mean is I don't think we understand the current rule and what exactly does it mean?
okay, I'm almost done, sorry.
That's good.
Page 53, there's a statement about questions from council. Again, this is during hearings, that we can only ask team members. Only team members can be questioned. And I believe our practice has been, we've been able to question the applicant as well. So I wanted to clarify that. And is that something we would continue that practice and change that we would be able to question the applicant as well? Okay, and then there is on page 54, there's a description of roles and responsibilities, I think, and it says the city manager sets the agenda for council meetings. I'm aware of several other cities where councils and several members of council are involved in setting council agendas. Like the mayor pro tem may sit in on those planning meetings with the city manager to set the agenda. Just wanted to put that out there as an awareness that there are other cities that do that practice, and is that something we may want to consider? So that is not just the city manager. I think the benefit may be twofold. One is that I see that we often, as elected officials, are aware of things that the city manager may not be aware of in timing and setting the agenda for certain items. And it may be helpful for us to have more input in that. And maybe that's the only reason I could think of right now, but just something to consider. And then I guess a question, Rachel, because I brought this up to you about Bob's rules and the friendly amendment discussion and the order of discussion and voting. Is this the time to talk about that, or are we gonna do that at a later date?
No, I think we should do that now.
Okay.
And I think you made great points, so.
Okay, so on Bob's rules, there's two things that are pretty explicitly spelled out in there that aren't our common practice of council. And one is the friendly amendment. So our practice now is that when a council member makes a motion and then another council member offers and requests it to be a friendly amendment, it is the decision of the member who made the motion whether that is a friendly amendment or not. Bob's rules argues that that is not good practice and that the motion belongs to the body and not to the person making the motion. And that it is up to the presiding officer to declare whether it's a friendly amendment or not. And then the body can challenge that and somebody, a member of the body can then say, I disagree with that decision. I would like to see it be voted on as an amendment. And that is the practice that Bob's rules lay out. And I think, and I agree to that thinking because I think that, you know, we've had situations that I can recall in the past where when you give the power to the person making the motion and they accept a friendly amendment that you may not agree with, then you have to vote on that with the friendly amendment. And so do you vote that whole thing down or not? And then it becomes, I think, a lot more complicated of a process and procedurally to vote that down and then have to bring it back up without the friendly amendment as an operation, where here it would be, you would first vote on the amendment before moving on and voting on the whole motion. Does that make sense?
If I may, I second that. We've actually had that issue twice on planning commission, once when I was the chair, once when I wasn't. And it was very confusing because some of the commissioners were misunderstanding, or they were frustrated that they didn't get a chance to vote, or what they were voting on wasn't clear. So I don't know if we've had that same issue on council, but we have on planning commission. And the friendly amendment, as I understand it, isn't written down anywhere. It's just something that we adopted.
Correct.
Okay.
Yep.
We have had this, it's not common, but we have had this before too, so I like this adjustment.
As I recall it, I think John made a friendly amendment to Bob's motion, and I thought we discussed it. I don't know why. I do recall us discussing it.
So there was an instance where John made an amendment to Bob's motion, but when I asked Bob if it was a friendly, John popped back in there and said he's
He
not
didn't want it to
making,
be.
he didn't want it to be a friendly amendment.
Right.
So then we had to vote on that,
Voted because it wasn't friendly.
which
Right.
was outside of our standard practice, but ironically is lined up with this new recommended practice and does have its merits because we actually wound up turning that amendment down, even though ironically you supported it. And if he had let it be a friendly, it would have become part of the motion,
But not under Bob's rules.
but not under Bob's
For
rules.
Bob,
Right,
right.
But so any amendment would be just an automatic vote
Yeah,
on.
it's just,
No,
it's
you
just,
can do a friendly amendment, but it's not up to the person making the motion to decide if it's a
yeah,
friendly
it
amendment.
becomes the presiding
It's then
officer's
the
call.
whole body decides, is this a
Yeah,
friendly amendment?
and
We
gets
just
to
accept
decide.
it?
Yeah.
Or do we vote on it?
Shouldn't we just short the process and just say, if you do an amendment, we vote on the amendment?
I agree. I think, I don't,
Period.
I
If
think
it's the
that could
body that has
still
to
be
decide.
confusing. Like, cause generally what would happen is I would look, okay, does anyone disagree with this? All right, that is accepted, which is an informal way of doing a vote. So I agree, we should just go.
Just go straight to a vote.
Just go straight to the vote rather than giving the presiding officer the power.
Because then you have it on record
Yeah,
that the amendment to the motion was approved or supported.
yeah,
Versus you trying to interpret a silent vote.
yeah, exactly. And I would do that, but there could be instances in the
I think
future where
those-
somebody would just go, nope, we're
Yeah,
taking it.
I don't know about other cities, but I know the state legislature, they don't do friendly amendments.
So
If
we
you're
do
making an
this-
amendment, you have to vote on it.
I think.
Let's just go that way.
Vote
I'd
on
rather
it.
go that way,
like
just because
that
it's
too.
just completely transparent and you
very
get to
clean.
see everybody's vote on it and
very
it keeps our legal nose clean.
Full consensus.
Rebecca?
Yes, I have a clarifying question on that.
No,
There also.
You can wait all questions to the end.
Write it down, Rachel.
Rachel,
We're on a roll.
a Kaiser roll.
So there's another rule that talks about friendly withdrawal of a motion. So do you want to eliminate that as well and have
Withdraw an amendment?
withdrawing a motion? So it allows, under similar circumstances, someone who has made an amendment to say, no, I'm gonna withdraw that motion and we're gonna do this differently. So it allows it unless there's some objection to that motion being
You should be able to
withdrawn.
withdraw it,
Yeah, I agree.
Okay.
because sometimes there's discussion around the motion. So you have to be, somebody might want to withdraw that motion after a discussion.
Okay, well, I really appreciate the discussion on that. So my last one on Bob's rules is the order, the clear delineation between when you are voting on a motion is the discussion of the motion and then the voting on the motion. And so this has gotten murky in the past that I've been on council where you know, we have the discussion and we are voting at the same time that we're having the discussion, and someone may bring up a good point that you may want to reconsider how you voted, and really it's an opportunity then to make an amendment, but you're already voting on the motion, so you can't make an amendment, so it gets really muddy fast. And so Bob's rule says that you should really make a clear delineation that this is the time to discuss, and at the time of the discussion is the time that if you want to offer an amendment, and if you want to, you know, state your position, that is great, and that may persuade others to go that way. And then you call for the vote, and there's not any more time to discuss and make amendments. You are now voting on the motion or the amendment if an amendment has been made. And so I would prefer that we try to make that delineation more clear. And I think it's important for the public. Well, you know, someone had made the point, well, you can change your vote, but the public doesn't know what's happening, and it gets very confusing then at that point. Well, what did you just do? And wait, is there an amendment? Are you voting on that? You know, and so I think that I think it's really important to be transparent and clear to the public about where we are in the process.
So if I'm hearing you, what I hear is, so I open it for questions, clarifications, all of that stuff. But this is not the point to discuss or argue the merits of the issue. So it's time for questions to gather all your facts. Then when I see no more lights in that section, then I ask for the discussion.
No,
a motion.
You have to
Then we ask
discuss.
for the
And then you have a discussion on the motion.
Okay, then we ask for the motion, and then I open discussion on the motion, and then I call the vote.
Seeing none before, that's how Dr.
Okay.
Cog does it.
I like that.
That's how we
Bob
run it
does
on
that.
planning commission.
Dr.
We'd say all members, please vote, seeing no further discussion.
Right.
Okay.
And then everybody
Okay.
would vote. But the thing is, and I mentioned this to Randy briefly, and this is just a slight difference. Planning commission operated this way. We actually would not allow members to vote until the discussion had ended.
Mhm.
So,
You
So
don't
I
open
I
it.
don't open the
Don't
voting
open it
until the
until-
discussion is ended.
and there may be
Yeah.
reasons to do or not do that, but that's just the way we had operated.
And just for clarity,
You can change
it's
the vote.
important for, you know, us, and obviously when we're doing public hearings, to state how we are going to vote.
Yes.
Yep. Mhm.
So for clarity, does that happen during the discussion? Or does that help? And we can do that? So you can state during the discussion period, I will be voting this way for this reason.
Right.
And then then it's closed, and then you vote.
Right, and that makes sense because then if there's something that you hear from another
Right.
council member that really makes sense, or, you know,
Yeah, what if you change my mind, Randy?
right?
Well, but we haven't opened the voting yet, so there's the opportunity, right?
Well, then I've lied to the public.
Yeah.
I'm just saying.
Well, then
It'll
you
be-
push your light and you get to discuss again. Randy, convince me.
Well, I think there's a third in here. It's a statement. Because you might have a discussion, but I might have a statement on my vote.
Mhm.
And so I still would like the opportunity to state my position when I'm voting. Because here's if Randy talks and says something and he says he's this way, he's gonna vote this way, and it's in a discussion, and then it gets to me and I convince him otherwise, you already publicly committed on your
That's
vote.
what I mean. That's what I'm saying.
Do that. That is
Yeah.
not good for you as an individual or the
That's-
public. You add
yes.
more confusion. So what you need to do is wait on your way to vote is at the
Yes.
time of the vote. Then you could state your position because then you've heard everyone's discussion before making a determination how you're gonna
Yeah.
vote.
I thought that in the past
If
that.
you say it too early, I think
Then we're lying to the public.
you are over committing and under delivering in a way.
So
Because you're gonna already state your position and I cannot persuade you
I
any
hear
other
what
way.
you're saying, and what I'm trying to prevent, which has happened, is that you don't bring up the point that you want to bring up during the discussion. You bring it up after everyone's voted,
Well, I know what you're referring to.
right?
Yeah.
But we've never called out a discussion window.
Right.
Frame. And so now that is there discussion, that's the time to discuss
Yes.
where you're thinking.
Right.
But you don't say what you're gonna vote just yet, because you should, out of respect, out of everyone's opinions, we should listen to everyone's
Absolutely.
opinions.
I agree.
And then when you call the vote, I usually, you don't vote. I don't push the button to make sure that it forces her to look at me. So I can say, it's a flag that I want to talk. And then I'm gonna say, based on the discussion or whatever, I'm gonna vote against this, and this is why. Because I already heard all of you.
Right.
But if you were the first one out of the gate and you already said, I'm not voting for it,
Right.
then you've committed your vote. You really
I
have,
mean,
and I can't persuade.
But I feel like I understand where Randy's coming from, where if at that point you say, and this is why, and you introduce new information that wasn't brought up in the discussion.
Don't say how you're gonna vote.
Yeah, just don't say
Just
how
don't
you're.
say how you're gonna vote. That's all I'm saying is discuss why you're against it, but you're saying at this moment, I'm not in favor of it because of these reasons. You can say that. Just say, I'm gonna vote against. I wouldn't come with an absolute statement is basically what I'm saying.
I hear you. Yeah, throw all your reasoning out, all your logic during the
Don't do your
discussion
absolute
piece.
yet.
And then save your vote. And then if you want to make a statement on your vote, you can say,
At the
Absolutely.
time of vote.
I'm voting yes because though I have all these mixed thoughts, I was very moved by Councilmember Mormon's statement. And so that
Exactly.
compels me to vote yes on this issue.
Because I know the dilemma you're going to.
Right.
Let's just
try that.
let's look at how we do it today. No discussion, we go straight to a vote, and then all of a sudden there's statements made, which is really a discussion. And what happens is
You could have offered an amendment.
I went in there and I said, I'm for it, blah, 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 blah.
Yeah.
And then all of a sudden, so-and-so jumps in and says, well, I'm against it. I'm like, damn, they just said that. And now it caught me in a dilemma
Right.
because I just told I'm for it when now you switch my mind. Well, I feel obligated to stay with my statement because now I look like a two-faced politician.
Yeah, you look like you're lying to the public.
Yeah. So I think you just have to be clear of how you frame your discussion is just a discussion and you're expressing your
Yep.
perspectives and just don't commit till
Yeah.
it's the voting.
But definitely bring your thoughts in the discussion. Don't save them for when the vote.
Absolutely.
Bring those thoughts.
That's the big thing I'm trying to avoid, because you could bring up a really good idea that we could have offered an amendment or something
Yeah,
on,
and then
and
save
we
it for
missed
the
the
end.
opportunity. So that's
Discussion,
yeah.
because the discussion can spawn an amendment.
All right.
Well, you guys have some thoughts?
Randy?
I have a
I'm done.
couple.
Thank you,
Um,
appreciate it.
And I'll go through
Go
them
ahead.
quickly, as efficiently as I can. This is just a clarification, BA 7.5.6. I think I'm misunderstanding it and my computer just went to sleep, so hold on. But essentially, this is, it says that city council members will have to direct their questions to the presiding officer, and the presiding officer will then direct the questions to the relevant party. Does that mean that we'll ask Lauren, ask a question for us every time?
Please don't make me do that.
Well, totally.
I could be misreading that.
It
No,
could be,
that's what it says, and I think it was pulled from the current rules.
Yeah.
Maybe not.
but I almost
that
feel like it
practice,
was
but-
meant to say, I have a question. She has to recognize you to ask questions. You can't
Yes,
just blurt
And
it
that is-
out.
That is.
So
Right.
I think it was more intended to say, we have buttons for it now. I have a
Yeah.
question. She has to say, I acknowledge you, and then now I can ask the question.
So maybe some retooling, because right now it says that the mayor will basically decide the relevance of the question and then has the discretion on whether or not to
Oh.
advance it.
I'm not doing that.
No, we've never practiced that.
And that would just, you would be throwing.
I mean, it would be
hands all the
fun.
time.
Oh, God, it'd be fun for all of you.
Yeah, I don't like that question, so. I'm
Take
gonna-
that out.
Okay.
Please don't make me do that.
Well, we'll keep rolling then. The next one is BA 321. This one I agree with. I just want to add something to it. It's representing council positions. I think it's important to represent council positions accurately, but I think it's also important to have the ability to have a discrete opinion as a part of the body. So I'm not sure what the language is exactly, but I think that extra piece is somehow missing from that.
So if I may jump in on this one, the accurately represent the position, I appreciate this. So we've been a part of hearings where we have had members disagree. I've been on a losing side before. What I have always said is, here is what the body decided, and every council member comes to their own reasoning for their own reasons. You'll need to talk to everybody. My vote was this, and here was my reasoning on why. However, I understand why my colleagues decided the way they did, and we will see that this is done as responsibly as possible.
I think that's totally fine. I just like to somehow, if we're gonna have
Yeah.
language dictating that, include that we can have our own sort
Yeah.
of discrete view on the
Absolutely.
particular.
But I also want to make sure we're not out there going against the wishes of the body.
No, you'd have to acknowledge accurately to the best of
You
your
can say I
ability.
voted against it, but
Yeah.
we've had poison in the well water. And so once we vote, the issue is done and that's the direction we go.
Yeah.
Even if you're for or against it.
Don't relitigate it.
Just gotta move forward. You could say, look, I disagree, but I respect the direction of the body and that's the direction we're going.
Yes.
And you stay fast on that.
I think that's.
I just want to make sure the wording doesn't open it up to say you can go and contradict the body.
Because that would go against accurately representing the decision that was made.
Correct.
Those are the only two kind of silly detail ones that I wanted to bring up.
Silly.
Just in general, I'm new to this conversation. It sounds like this has been going on for quite a while. But I am very nervous about limiting public comment at all compared to what we currently do. And that includes looking at where the residents are from, because I mean, Arvada's Swiss cheese, right? There's little patches of unincorporated Jeffco all over the place. So a lot of residents may not even know if they're in the city of Arvada. And the folks that are on the periphery are affected by the decisions this body makes. So I think there's a good case why they should have an opinion. So I just wanted to put that out there. Also, the 2 to 72 minutes, was that just 1 year or is that ever?
25, just in 2025.
Okay, so 25 wasn't a terribly.
Well, you need to know the
year.
median and the average because there's
Yeah.
probably more in the
Yeah.
60 and 72 than there was in the 2.
Because 72 sounds light. I haven't been to as many council
I remember
meetings.
one, I think went almost 2 hours. I
Right.
feel like there was
Yeah.
one longer, but
There's been a long one this.
I think if you look at the median, if you pull the median, I bet you we're on that farther side.
Right, and so in that case, in general, nervous about limiting time. But if you look at that case, then the 30 minutes or an hour, as Randy had mentioned, it doesn't mean a lot of difference in terms of the overall kind of operating capacity in an average over a year. But the optics on that are going to be bad. And that's my thoughts on the matter.
Rebecca.
Yes, I had sent some questions over, so I would love to dive deeper into the data we have. So with that, you had said 22 business meetings so far in 2025, the length is 2 to 72. I think basing it on that and potentially limiting public comment, but looking at what the average was, and it seems like the goal is to change this so we know what to expect. So let's see what the data says for how often we're going later and then making the number within that. So like you said, an hour, if it was as long as 72 minutes, an hour is only cutting 12 minutes off, whereas 45 is. So I think it's looking at how often folks or how often we're extending longer. And then I think because this really is the only opportunity for a resident to speak to us in public, on the record, with all of us there, I think being really mindful of any decisions we make. There was a note, and I don't have exactly where, but about the mic being turned off potentially. That to me seems more reasonable as you're campaigning. If you don't speak in your 3 minutes, you are cut up. That to me seems more reasonable than maybe cutting the entire public comment. It's more like you've got to get this down to 3 minutes or the mic will go off, which also takes away the friction of you having to be, it's just like you're done. So that's potentially an option. I mean, they have the countdown. And then I think that was, that was all the comments I had.
All right, I'll play a different
Rev.
role than all of you.
That'd be roughly Eddie.
So I think one thing you're missing in the keywords that Nora's explaining is the holistic view. All of the meeting is public comment. There is different phases of public comment. I think we're microscopic look in just a segment of our business meeting. I get complaints that the mom or dad has to stay till 10 p.m. at night because we need to hear about, stuff that's happening with ISIS or Israel or Palestine or federal policies that are way beyond our scope for 3 hours. But I have a public hearing about somebody who wants their fence to go to the infringement of their property, who lives here, has to wait till 10 o'clock at night to do their rubber stamp hearing. That is a citizen with a real issue that voted for us, pays taxpayers here, that expect to be engaging with their citizens, their representatives. But we spend 3 hours listening about puppy mills to the war on ISIS. There's things way beyond. And so my complaints I get from folks, because all the development happens out west, is why am I waiting to listen to stuff that's way outside of your guys' control? Not that I want to limit the comments. I think they're fine. I'm willing to listen to them. But when you talk about equity and fairness, it's unfair to put a public hearing, people here for a purpose that is directly impacting their property, their livelihood, their business late at night, because everyone else gets first bite at the apple. So I would actually argue that we are doing a disservice to our city business meeting that affects our citizens and allowing everyone else to have the mic. So what I would propose is, one, I do like the limit. I think that is great. I think our citizens should have priority at public. My recommendation was, let's try to get the business stuff out and then let everyone have all night. I will sit here till 2 a.m. if we need to talk about those things. But out of respect, out of our staff, out of the respect of the citizens that have a true impact, that want their voices heard, let's get them in early, get home, get to their kids, their family, and dinner, get them out. And then let us be here till 2 a.m. listening to puppy mills and whatever comes up that's new. And I'm okay. So I don't want to limit the conversation. I want to just move it out of respect for efficiency to our current residents and businesses.
Well, I feel like you're just reprioritizing it, like which
Yeah,
ones
that's all.
do we hear first and why? Let's hear the stuff that's actually
Yeah.
on the agenda and relevant to what we set out and publicly noticed.
Yeah, and then let's move on.
And then move on to, the free speech. And I think that is a better balancing of rights, because right now I feel like the people who are getting discriminated against for having the infringement are the people who have to wait to hear unrelevant stuff that's not related to the business agenda that's been publicly noticed.
Yeah, because we don't know when they're going to come and who's going to come and talk about what. So, one of the proposals we offered was, let's have a quick pre-meeting or a pre-public hearing on the resolutions and consent items. Hey, does anyone have a question on the existing resolution and consent agenda? So that was one proposal. If none, then we go straight into those consent and resolutions. So, because right now we don't let people comment on any of those. So I thought, well, let's give them a little window to comment on them before we vote on them. Then we vote on those, then we go into public hearings, get those folks out and get them rolling. And then we can do public hearing all night. I'm okay with whatever the
Public
topic's going to be
Yeah.
all night long. But if you think of that, what my question would be is, how late have we started public hearings because of that? It's not necessarily how late have we gone. How late did we start them? And on average, at least anecdotal, I don't think we start public hearings till 7:15 and 7:30. And we publicly show them at 6:15.
6:15.
So now everyone comes here to do public hearings at 6:15 and they're like, you gotta be it. I got my butt reamed later on the CDOT one. You know which one I'm talking about, where the guy
Yeah.
was pissed and I had to recuse myself because he was there waiting for his to be heard at 9:30, 10 o'clock at night, and came here at 6:15 expecting to have public hearing, but he had to listen to the puppy mill stuff. He's like, you guys are messed up. But anyways, he was not very nice. But that's a good example of where somebody does come to present consultants. How many hours are people paying for consultants to sit there to be part of that? So it's affecting the business, the construction, the development. And then we have all of our staff that has to sit there. How much money are we causing the taxpayer in the projects when we talk about affordability and housing and so forth? And yet we're saying, well, you need to stay here for 4 hours so we can get through this. So yes, you are spot on, Shauna. All I'm asking is re-swizzling who gets it and just push some stuff forward and get, because the public hearing, I don't think I need the city engineer to be here. If you want, you can. But if we're doing 4 hours of puppy mills, then we could,
So that's why I feel like the time limitation of the first public comment allows us to actually, it's a good compromise, because it allows us to have the free speech and pay attention to that, to anything that might not be on the agenda, but then actually get to the agenda that we noticed and people are expecting, and then have the second public comment where people can talk about Gaza,
Exactly.
who's
So we could-
president.
Because
Yeah.
the presiding officer can put all the Arvada residents first.
Well, I actually
Yeah.
have some opinion or something about that, but I'll let Bob finish your.
Well, yeah, I'm kind of repeating myself now, but and I'm okay with the 30 minutes because I do think that there are some moms and dads or families or somebody that just want to come and talk real quick and need to go back to the
Right.
house. So maybe that
And
worked as a,
scouts.
well, and the scouts, yeah, I just got a phone call for some coming next
Yeah.
week, but
Mhm.
they, so maybe that 30-minute works, but if we're efficient, they're not gonna stay late. Or we're gonna get through the public hearing. So that my
Mhm.
thought process was, even if we didn't do the 30 and we said, hey, does anyone have any comments on resolutions? Or we kind of bundled that and there aren't any and there's no general public, we may get through those other items fairly quick and then allow a good public hearing or public comment section that could be lengthy and it's early still. So I would be interested in how late have we started public hearings? Because
that's-
I think that's gonna be the key of how many times we were probably an hour late. I do think residents, Arvada residents should have priority because they're here for business that's directly impacting them. Like I said, they're the taxpayer, they're the business owner. I shouldn't say that. Arvada residents and business owners. I should add business owners too, because they have direct business with the city. I did talk about limit and then going back to the 5 o'clock was an agenda setting meeting. That's what the intent of the 5 o'clock was. I don't think you ever said that, but it was posted. I remember it being posted. Maybe we talked to Chris Oak. I thought it was. She said it never was agenda setting. I know Mark Williams always called it an agenda setting meeting.
Yeah.
Maybe it's not official, but technically that should be an agenda setting meeting and dinner and you know, I know there's a lot of discussion. I don't want to get rid of the 5 o'clock. I know there was some discussion around that. That's the only time we have an ability to talk as a body informally and casually and have these conversations and sometimes they're crucial. I don't want to get rid of them, but I also think that that's an opportunity that we as a body could discuss the agenda, not just the mayor.
Yeah.
But we can discuss it. I also want to be a little thoughtful of not really inserting ourselves into the agenda because there's city business that has to get going. So I think what I would suggest is the staff says, here's the agenda.
Right.
For these coming, this, one in a month from now, is there any concerns or do you want to add anything? And then they can come back and propose a new agenda. But at the end of the day, consent and resolutions and the business stuff's transactional in a way. I don't want us to mess that up. If there's something we want a discussion around, I think it usually shows up at study sessions and workshops. Those are the ones where we're like, hey, we want these topics to come forward. Unless the staff has something to do as well.
Resolution last week.
And you actually can, I'm gonna go ahead and note, we have 35 minutes before the business meeting. Why don't we go ahead and take a very short break, grab dinner, come back, we'll continue the conversation.
Do you want to train a thought real quick?
Can I just add
Yes,
to
you go
this
ahead.
really quick? So I think, and part of what I didn't say earlier, but part of my own frustration, and I hear this from the public as well, is that I don't have clarity on the next several meetings ahead, what's on the agenda.
Yeah.
And I go to the website and it doesn't show it. You won't get it till the Friday before. And so as a council member, I find that a little frustrating and I know the public is frustrated by that. So I would love to see if we can post more of in advance what the agenda is and when the workshop, I mean, the workshop's a little bit, we get more clarity because that's always at the end of our package.
Shows it.
But other than workshops, I have no idea 2 weeks from now what we're doing.
Well, and on that point, I don't think I agree with you, but I know it can be hard because sometimes it's like when like an application is done, then it gets through and I don't know how much advance notice the city really has on like exactly when, but I feel like, at least in the next 2 to 3 months window, like that's why I like the Friday memo that says, here's the development meetings that are happening.
Yeah,
Because then
I
I'm
want
like, okay, I'm gonna see this in like 6 months to a year, right? But then I kind of forget. I might see it in the memo and then it comes on the thing. So I think there does need to be something in between those two of just knowing generally, like quarterly, what can we expect to be on the
If
agenda.
I may, what I'm hearing here is, what you're saying is the manager will set the agenda in consultation with council.
Mhm.
And how that actually unfolds is more
Yeah.
internal
Mhm.
procedural matter. Would that work?
Yeah.
Yes.
That call for titles.
And the last thing, and then we go get it, mine's
Yeah.
easy. the clock is great. Talk about being friendly, like Rebecca brought up.
Mhm.
But man, when you put it on a big TV like that, I hate that. And one, I sit in front of it, so I deal with the mean eyes and the firing eyes. You know, what I noticed in other cities do, they put discrete clocks where they can see, the person can see it and we can see it, but they're discreet where they're not necessarily like in your face and somebody's
On the
clicking stuff.
screen.
Well, like a little timer that pops up on a little clock
Yeah, it's like,
display that might be down low or
We need
or
to
put it up in the back
modernize
where the
our
other clock
stuff.
is for us, but
Anyway,
one for them. But is there some way we can be a little bit more respectful and discreet
go
versus,
take a look
putting
at Edgewater's setup. It's,
That's very
it's
nice.
very nice.
let's grab some food and we'll come right back.
Leads to having to redo our chamber.
Part of the redo, Chamber 2.0.
Yeah.
Indeed. Thank you for putting all that together. I'm sure that's a lot of work. I went through as much of it as I could possibly get through,
Yeah.
but it's
But it's interesting.
yeah. Yeah, no, thank you.
Well, thank you. You're welcome.
Thank you, thank you. I only had a few items then regarding as well. We kind of talked about a few of mine. So on page 7 of the clean version, it says if both the mayor and the mayor pro tem are unavailable, the member who most recently served as mayor and then most recently as mayor pro tem. I think that's a relic from pre-1991 that we haven't cleaned these up in some time. So no one will have most recently served as mayor because the mayor is no longer rotational. So that's just something to clean up. Same page, item 2.6.1. In-person attendance not required to establish quorum. So what I took this to mean is, and what this is basically if we have somebody who is remote, we can still count that towards counting our quorum. However, later in the document, we talk about how that person can participate in the meeting and vote on legislative and administrative matters. However, they cannot vote on a quasi judicial. So given that, do we want to just clarify this? That not required to establish a quorum except in quasi judicial matters? Okay. So that one, same page, very bottom, 2.7.2, duty to vote. A member who is present in the meeting, blah, 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 formal vote of the meeting, unless excused by unanimous vote of the remaining members or because of a declared conflict of interest. So basically, what this is and we saw this very recently, we had a member disagree with another member's request to recuse. I don't think it should be unanimous, it should be majority. Allows us to would allow somebody to recuse themselves.
I remember that.
You shall not recuse.
Yeah.
Also, there was no discussion. Did you see
Yeah,
that?
yeah,
If someone makes a motion to recuse, there's no discussion.
I saw that too. Yeah. And it also has all members present, including the one who made the request, must vote on the motion still in regards to recusal. Isn't our standard practice that that person is locked out and the other members vote to recuse?
So.
Yeah.
You're right.
So, yeah, because I'm pretty sure, I've never had to recuse myself, so I can't remember, but
When you recused yourself.
yeah, you.
I didn't vote.
Yeah, exactly. So I just want to make sure, are we lining this up with our current procedures that we do? It's okay if we do it the other way. I just want to make sure I have clarity as presiding officer on what we need to do. And it does say if excused, the member must leave the chamber. Historically, we do that as good practice, but we haven't always said you can leave the chamber. Sometimes I remember Nancy Ford was allowed to stay on the dais one time for a very routine thing. She just sat there and didn't vote. So I think just that clarification of the excused member may leave the chamber or something, or must if requested by the council or something like that.
Get out.
I think they're recused. I think they should just leave.
Yeah.
Yeah.
I think they should
Because there's a presence, if there's a
Yeah.
presence on the dais, it doesn't look good.
I agree.
Agreed.
Yeah. Can we change it to be escorted out?
By the police chief.
By
a uniformed
officer. No, I'm totally fine then with, but yeah, that was just clarity for me as the presiding officer. So same here with the consent agenda voting. It said 2.7.4. Prior to accepting a motion for adoption of the consent agenda, the presiding officer will ask the council members present if they wish to discuss or comment on any matters of the consent agenda. We never do this. do we, like, that's the whole point of it being the consent agenda, is that it's not something we take one by one and discuss. We have the ability to ask in advance to remove an item from the consent agenda if we wish to have discussion on that. So I think we just need to align that language with modern practice.
And that should be discussed at the 5 o'clock as part of the agenda setting.
Yes. And then same paragraph, if the vote is not unanimous, the members will then vote on each matter separately. Again, we never do this, so we've had a member vote no on the consent agenda once or twice before, and we've just read it as 6-1. In that case, this, according to these laws, that we should have undone and then taken them one by one. So if we would rather do that, like as it's written, it's fine, but I'm perfectly fine letting it stand 6-1. Or 5-2, or whatever the vote is. It's almost always 7-0, but.
If you're gonna say no, you should just call it out anyways.
That's the thing,
That's what we've done, yeah.
Yeah, exactly.
because you would be in opposition to one of the items on the.
Not all of
agenda,
them.
All of them.
Yeah, so you should pull it out.
Yeah,
So you should pull it out.
yeah. So if you're opposed to something, just request it in advance.
Right.
Page 8, 2.9, there's a typo in the third sentence. I'll just show it to you here.
Accommodations.
Governed by the charter code, comma, I think it looked like that's a period. There's no word, and then provision is lowercase.
Yeah.
So it's just a, yeah.
Yeah, about suspension for
Got it. Thank you, Nora.
accommodation. Yeah, thank you.
So in page 9, 2.11.1, late meeting. So to Bob's point, going till 2 o'clock in the morning, the current bylaws don't actually allow us that option. So business at hand, the meeting will be limited to business under consideration at 11. Activity of the business consideration 11 may not exceed 11:30. And then, or we have to continue the hearing, or we're allowed to extend the one item a little bit later. Historically, what we've done is we've taken a vote to continue the meeting
Right.
going into rather than cut it off.
It's usually the hearing.
And so I think the language here just needs to be modified to note that we're doing that.
We can't, and I think that's how the current rules read. So
Okay.
what the current rules do, if I'm recalling correctly, is it puts another section in there that tells you if you're not going to do this, you have to vote to set aside the rules and then vote
Okay.
to go later.
Yeah, thank you.
So I think it's the same procedure, but we can call it out specifically here.
Okay. Yeah, I just noticed that and I'm like, we've always kind of done it this other
Yep.
way to suspend the rules.
Correct.
You're right.
Now, let's clarify something here, because if we do end up limiting the public comment or rearranging how that efficiency goes, those public hearings, let's just assume we have no public hearings, or maybe one, and it goes till 6:30, but now we have 4 hours of public comment. So the public hearings already taken care of. It talks about public hearings going past 11 o'clock. So what about public comment?
Mhm.
You know, do we allow that to keep going, or do we only allow that exception to happen when it's public hearings? So it kind of
right now, I
limit,
think it's for, excuse me for
Yeah.
interrupting, I think it's for any meetings.
or any meetings, it doesn't say public hearing?
7 o'clock PM, if a meeting has not previously been adjourned, further proceedings shall be conducted as follows. And then it goes.
Okay,
through
so
the-
it doesn't call out public hearing. Okay, okay, that's fine then. Took yours off.
Hold on. Somebody had to bring up my notes. All right. And this is just a point of clarity question. I just want to make sure. So page 14 at the bottom, BA 2.6. We suspended hybrid meetings. We're told we don't do them anymore unless we absolutely need to. So here it has listed when the member has good cause to be away due to a personal or family emergency or for another unforeseen reason. So I struggle with this one a little bit that, we can't do it when you're on planned travel and you are, in a hotel room and quiet and everything, but we will allow it for when you've had a personal emergency and theoretically things may not be quite as good for you.
Yeah, we wouldn't want,
Yeah.
nobody wants to meet the.
As somebody who has zoomed in for a meeting, experiencing a personal emergency and out of town, it's not fun. I don't want to ever do that again. And so,
I think the remote, having hybrid is not a
Yeah.
fan of anymore, just because some of us who have been remote, it's so hard to engage and have your voice heard.
Yeah.
It's just not worth it. I'd rather you just not be here.
Yeah.
It's not good for people in the room or the person remote.
Well, I agree. It also sends a better message to the public because they can't make their comment remotely anymore.
Right.
So,
Mhm.
We shouldn't be doing it either.
Yeah.
yeah.
I think we just have this only in case of emergency, then we will allow hybrid, because if we desperately need the quorum or if we're out of town, but there's been.
Right.
Or if like Bob
There's
is
an
caught in a
emergency.
snowstorm
Yeah.
Yeah.
over the mountain and
On
can't
our
get.
pass.
I'm not gonna be like, hey, hold on, I'm trying to go to the
Please don't do that.
But
Do, it'll be fun for us.
It wasn't in the rules at all until COVID.
Yeah.
So it was something.
that's
totally
what I was gonna go to is,
Yeah.
it's like for a declaration,
Situations,
emergency
yeah.
management stuff, like
Yeah.
we need to pull together, but.
Yeah.
Right, we're not all together.
But-
But he's driving
But
it
no, it
elsewhere.
started.
Yeah, I agree.
driving
The
it.
remote is for, I loved how we were wording it with the remote meetings because of snowstorms thing. I think hybrid just needs to be the same thing. Same
Or we
general
make it
guidelines.
all remote and all in person, no hybrid.
And I don't have a problem with getting some people in hybrid, when we really need to. But limiting it for those cases.
When you're stuck on one or.
Yeah. All right.
CDOT, we're never stuck.
Uh,
I know that guy.
All right, my comment on page 22, VA 6.2.1. I agree with Randy that half an hour feels too short for me. I like the recommendation of an hour as the balance to both keep the meeting time flowing and respect those who are there for hearing business and other things, but also allow time for our public to be able to come in, get their comments heard on unrelated things.
So you're
and
gonna
then-
tell, I just wanna make sure we're clear on this hour.
Yeah,
When we say public comments at
7:00.
6:15, at 7:15,
yeah,
because it will go to
it will, yeah,
6:15.
I agree.
Just so you know, all the people that are there for the reasons I explained.
Yeah,
You're gonna be an hour plus because we're not gonna let you talk because we're gonna let everyone else go.
yes,
That
and
could be people
I
from outside of the city.
trying to look at, no.
Like 45 minutes.
Well, I think we can also refine these, so maybe, I also think jumping to half an hour is a very sort of extreme thing for our residents to the point of change. That's a big change from what we currently
So
have.
can I offer this to everybody? They'll give us a range, give us what the average and the medians are.
Mm-hmm.
Because if we only have, like you had last week, one person, it's gonna shorten anyways.
Which is what it used to be.
But it used to only be one or two or three
Right.
people. This is a null issue.
Mhm.
But if you publicize, I'm gonna give 2 hours or an hour for it, it could get loaded just to
Yes,
push
that's
something
what-
out.
Uh-huh.
And I've seen a lot of people from Denver and other cities coming in here to share their politics into our city. We need to make sure that we're respectful of our city residents and taxpayers first and foremost. So I just think we need to be very careful of saying we give up to an hour of public comment when if you go look at the list there, not everyone does that. We already give 2, which is above and beyond sessions, and we're giving longer times.
The other thing to think about, as I was going through and collecting the data on how long public comment was, the beginning and end, all that kind of stuff. But I also compared it to the total meeting time. And there are times where it is over a third or even over a half of our meeting time. So that's just one other data point to kind of throw out there is that if you limited it up front to a certain amount of time, it will take less time to do our business a large majority of the time than that.
Oh, I agree.
That's
why I believe in the compromise.
I just wanted to bring up what Mary Simpson said, resonates with me, that it didn't used to be that way. You have these long periods of public comment.
It used to be, what
People are angry.
I just want to put it out there as a counterpoint. Are we addressing a symptom of other issues by limiting public comment? Why are we having so much public comment?
I just wanted to point out one quick thing. It will be the same amount of total public comment time.
Just
So we
rearranged.
won't be limiting the total time.
Right. But for the same reason that it's inconvenient for people that are on the agenda, it's inconvenient for people that
Want to talk?
want to come in and
Comments.
it's very nerve wracking. I've done it many times. It takes a lot of intent and belief and motivation to go stand up there and say something.
So out of the 14 years, I will tell you, recently it is national and international topics
Okay.
that are drawing people to come and speak. I would say, just anecdotal, and you all are on the dais too, I would say probably 75% of what's sometimes talked up there has nothing we can do about.
Right,
And the
and,
puppy mills is a real one.
and as silly as it may seem, and I totally agree with you, I don't disagree with that, but it's kind of a part of what's special about the meeting in the first place.
And we're fine with it, but it's also disrespectful for the person who's here for a variance on their fence. And they're here till 10 o'clock at night just to move their fence 1 foot.
Yeah.
You know, because we have to listen to puppy mills.
And democracy is a messy business. I mean, I hear what you're saying. I don't.
Like,
totally disagree.
is that, like, what is the spirit of a totally open public comment not related to the agenda for? I feel like it is for when our residents and people need to address us about something that we didn't put on the business agenda.
I agree.
Right? That's what I feel like. That's the spirit. It is not for people from, national to come talk about their politics. It's not for people from other states. It's not for international things. The reason why we have an unstructured come and talk to us about anything and we'll listen is because if we set the agenda and they need to tell us something that's not on the agenda, I feel like that is why it is there for being able to redress the wrongs. And it's intended to be like from our community, and it's getting abused by people who are not from our community and their First Amendment rights. I still want to respect those First Amendment rights, but put them at the end of the meeting. And I would like Bob, I will sit here and listen. That's why I think 30 minutes, honestly, is a good reorganizing of the agenda, not limiting free speech, but putting the speech of why we're having the meeting, prioritizing that speech first. We first start out with like, is there anything we should be addressing that's not on the agenda? That's what the first public comment should be about mainly.
Right.
Then we address the things that are actually on the agenda that we timed and noticed and told people that we were going to be speaking about, respect that time. And then if you want to come and talk to us about what's going on in Gaza and all those other messy democratic things, that's great. But it doesn't need to be the first thing on the agenda that everybody else is beholden to. Because what is the purpose of the meeting? They can also go to the state legislature and talk about those things. They can also go to, meet with their congressional, they can go to the Council of Foreign Relations. Like there's so many different places where this democracy can serve those issues that they're allowed to go to and speak as well. And so I feel like I want to get to like, why do we have a public comment? It is so that if we mess up or not mess up, but have an agenda and a citizen needs to bring it to our attention or something we can actually act upon, we don't know about. That's what I feel like what we want.
Yeah.
And
But I
why
don't
we
know
have
how do
that.
we get that?
It's up to the
But-
presiding officer.
And I have
Yeah.
opinions about that too, but I think that's why we have it. And I think that is honestly what happens most of the time. Most of the time,
does.
people are like, at the
My
short-term
stoplight.
rentals, somebody got shot.
Yeah.
And I want to know, what are you doing about it? And I need to tell you about what happened. There's homeless people in downtown that are ruining my business. And they almost set my roof on fire.
Yeah.
That's the kind of stuff I want at the public comment. And I think the way we structure the meeting makes that possible. If we say 30 minutes is at the front, prioritize residents
Businesses.
and businesses, right? And then, if you want to talk to us as your constitutional right, but I feel like we are infringing on other people's rights who came here for the business that's on the agenda by not prioritizing. And so I don't want to limit people's access or time. I just want to reprioritize what's in the agenda. And I have a few more things to say as well. And because I know we're going to have more discussions before we make any final
Yes.
decisions on this. So I don't think we're going to get through everything tonight. But I also want to set it up so that the PO actually has as little discretion as possible. Like I want it to be 30 minutes no matter what, not 30 minutes at the PO's discretion. And the reason is because when people want to come and talk to us for hours, they're mad about something. And if the presiding officer has the discretion to say, all right, you people mad about trash, I'm putting you to the end of the agenda. But you people who are mad about homelessness, I'm going to let you speak for hours. It's going to seem like there's a political agenda behind it based on which topics you decide to move to the end or keep up at the front. So I just want to make it as equitable and, forward thinking as possible this is pretty much what we apply in every city and make it like very extenuating circumstances where the PO is like, okay, you know, I'm gonna put in my discretion here. And the other reason why I want the PO to have as little discretion as possible is because I want it to be a collective decision of the 7 of us. Of like, this is how we decided to structure public comment, not what is Lauren deciding or whoever the next, or Randy is, whatever, or Bob, you've been the presiding officer. Right, like,
I actually appreciate that as the person who takes the punches anyway. I appreciate having it really, the body says we did.
yeah, and I think it also minimizes our risk. You know, if we,
It's not
from a
subjective.
legal perspective, if it's just the way it is. And then we're turning off the microphone. I think that's great. I think it's rude, but I think it's great. And then,
Versus having Lauren.
yeah, be like, okay, you
I
can
like
wrap
the
it up.
ability to be like, I'm gonna give you a few more seconds to wrap your thoughts, but maybe if it's,
Yeah.
they do, but so maybe it's at like 3 minutes, 15 seconds. Cut them.
And I said I'm in favor of looking at pooling, and I also agree with Randy that the informal meeting should be at least live streamed, if not also recorded and broadcast somewhere else in this building live at the same time and at home, because I do think access is an issue, snow is an issue, driving at night is an issue, and there's just not enough room for people to sit here and watch, and also for all the staff to be here for those informal meetings. So I really want us to live stream it. And I think that is all. Okay. None of those are questions, sorry.
Okay, no, it's okay. I only had a couple more.
Okay.
Page 23, BA 6.33. This one's just a clarity. It says to reduce the potential for noise or sound interference, only one person at a time may present a microphone. And I would just like something in there, and unless allowed by the discretion of the PO, just because like when Ed Tomlinson came with that young lady for the parade, she mostly just stood there. And then recently we had Ms. LaFoon and one other person talking about like a block party or something, and they were there together. And I'm kind of okay when they're actually together,
Speaking on the same.
speaking on the same thing. And so I'm fine allowing them to do that. It hasn't been disruptive.
I
So,
have a kid who says cheeseburger. I love.
oh God, mac and cheese.
That was a good one.
Mayor, I have one quick comment if you don't mind.
Absolutely.
All right, so just a quick comment. Ms. Ambrose, I agree with a lot of the things that you're
Reverend
saying.
Ambrose or Councilmember Ambrose. Yeah.
Thank you. Appreciate that. I agree with a lot of the comments that are being made. I think that these haven't been made clear to the public though.
Exactly.
And I think that
Yeah,
they're
we're gonna
gonna
have to do
feel
that. Yeah.
sort of like, whoa, wait, what? All these new, rules. I think there's an opportunity to
Centralize
say,
it.
look, this is intended to be used for X, Y, and Z purposes. We can't regulate the content of your speech, but understand that you're getting in the way of what this is intended to do. And I think there's an opportunity to make that messaging clear before.
But I don't know how much we can actually do that officially.
Mhm.
Because if we say, we actually only want these kinds of comments, then it runs into First Amendment. That's why I'm saying the structure of the meeting is how we draw out what we get rather than the public. But I agree with you, like a huge slew of changes at once is going to be hard.
But
So
The perception's gonna be though, that
Yeah.
we're trying to limit their comments on the things that you think are important.
right.
Like
yeah.
what's happening in the city. That's what's gonna be perceived. They're not gonna
Yes.
think they don't want to hear about the Gaza and the puppy mill stuff.
Right.
They're gonna think they don't want to hear about homelessness and development fatigue.
I mean, and I feel like that's what we can do on one-on-one constituent education, but like the city to take it that stance and put it out on like in the Arvada report, like that's gonna be First Amendment, like.
But
yeah.
keep this in mind, our public is already confused about all this anyway.
Right,
So-
that's true.
So the good part is we get to clarify, we get to publicize, and we get to it is some change, but right now, change from what confusion they have already. So I think it's a good opportunity to realign ourselves and show equity and fairness and efficiency. We should be efficient as government. That's a big thing. So I think it's a great opportunity to, I think we should put how do you engage with your council member flyers up in the
Right.
front?
Not on next door.
Yeah, exactly. Like,
Yeah.
it's not official on next,
Yeah.
it's official if you go through Ask Arvada, and those kind of things, a little pamphlet that somebody can keep. I think would be super nice.
Yeah.
Yeah, clerk's office on that. So Mayor Simpson, if I may, in light of our time, is our next step to bring back a new draft, obviously trying to incorporate as many of the suggestions as you have as possible around this public comment piece. I don't want to ask for a vote, obviously, but if we were to, I'm hearing everything from a half hour to an hour on the first public comment
Or
period.
no limit.
If
I
we
had
were
add
to-
that.
Or no limit.
Or
Or
no
no
limit.
limit. Yes.
Or no,
Like it is today,
Yeah.
basically. is what it is.
Exactly.
say that again.
It's like it is today. There's no
It was
limit.
the
on
current-
first.
the current
No
structure.
change, no change.
So
So.
understanding
We don't
there's,
have-
that's a continuum.
Yeah,
What's
what
the
we have
direction?
here,
With
Yeah.
45 minutes just to find a compromise or leave it so that you have some time to mull it over in the next draft or what?
I mean, we don't decide, if there isn't a clear direction here, then it goes to the dais and you present us options and we discuss it publicly and vote on it.
Yeah,
I-
that's kind of it's what I was going to suggest because I don't know, given the discussion today, that you're going to come to any more of a consensus than you're at right now. So, there may be some things, if there are some things that you would like to discuss and debate more, let's talk about those things. Let us know what those topics are. But we can't, I think otherwise what we would try to do is try to glean from the discussion today what might be the most appropriate options, given everything that you discussed, make those changes and then put that up for a vote.
If you give us
Unless-
some data on how late did we start?
Yes. I would
On
like
public
to see that.
hearings and what is the median and average of those comments? Because I think we need to be very,
Mhm.
don't get so fixed on that first public comment. Look at the whole meeting. Because the whole meeting has opportunities for public engagement and discussion. So like, we need to stop looking at the first, hey, as the first one to get seated at the restaurants that just opened.
Sure.
I think giving the 30 minutes is kind of nice because they did come up early, but let's look at the whole process because I think there's some fairness around that.
Most meetings, 30 minutes will cover all.
Yeah.
That's what I would like to know, because
That's
if we
what
come
I'm
back and say
thinking
the average
too.
is 30 minutes,
Yeah.
then this is a no-brainer because we're already seeing data that says. it's
Then
30
just leave
minutes.
it as is.
And then do we allow pooling in the first public comment then? So if we have 20 residents
Oh,
on
no,
Puppy
pooling's
Mill.
only on public hearing.
Yeah, I know, but then I'm opening one more can of worms. If we have 20 residents who have come to talk about puppy mills, do we allow them to pool?
Their comments.
So in the public comment, just, no, okay.
So we really didn't discuss that tonight. We can come back with language around that, but it was not a topic of discussion tonight. The only thing discussion was around the hearing piece.
Yes.
And at the end of the day, you can move forward with this. And if you decide, oh, I love public pooling so much at public hearing, we can go back and amend it and add it at public comment.
That works. And I am pro pooling for tax too.
Thank you so much.
So turning.
Do you have anything from the city manager?
You're not gonna tell us now.
I'll get back to this.
So it's here.
Like.
Really sort of.
We're gonna do this.
Oh, yeah.